I don't want to go to trial. That's it. I don't want to go to trial. I have clients tell me something like that all the time, right? They first start off the case and their first worry is that they're going to be in front of a jury and that they're going to be facing a group of their peers about something they're maybe worried about, right? Or maybe something private. I'll tell you first off, if you're starting from that point, you can take a deep breath because that's often most cases, right, can be handled before litigation. So I always tell people, let's start off and see what we can do. And I say that to anybody looking at this going, what should I do? I'm afraid to move on the next step. I don't really want to file a claim. I don't want to really file a lawsuit. And so you start first. It's good to talk to an attorney, right? That's the number one tip because you can kind of understand the perspective and what the options look like. And even from there, I'll just say the simplest thing is the likelihood of you going to trial is just so darn low that I don't think you need to jump to that worry. So first off, like I said, most cases are going to be handled pre-litigation. We'll get your medical records. Maybe it's a straightforward car accident, clear liability, can settle it all the time, right? I got a case right here where I got the check today. Client's case was settled, was paid within policy limits, all said and done. Never had to litigate, never had to file a lawsuit. At the same point, had a case the other day where I had to resolve the matter. We got some insurance money, but one insurance company effectively flipped us a bird. Talk to the client, and we need to file a lawsuit. Now, first step for a lot of people, that's scary in of itself, right? It will put your name in the public record as you filed the lawsuit. Now, I think a lot of people, somebody call, right, and people say this all the time. I'm not the litigious type, or I'm not the type to bring a lawsuit. I think that's a good place to start, but you need to remember too that companies have for years made it seem like a shameful thing to bring a lawsuit, when in reality, it's really something that's brave. You are standing up for yourself. You are saying, someone wronged me, and I'm going to stand up and put myself out there and get what I deserve. Deserve some kind of compensation, some kind of justice. And so that's really where you're starting at from, and where I'd recommend you start from when you're looking at bringing a lawsuit. And this is just, I file a complaint, I draft it up, I send it in, and send it to the other side, and we start litigation. The next thing you can expect, and this is probably a couple months or maybe a month after the lawsuit is filed, the defendants or the defendant will send a set of discovery, right? Going over all the questions. They'll ask for all your medical records. They'll ask for a lot of information about you to make sure the case is legitimate. A lot of cases can settle right there. Maybe what happened is that the insurance adjuster thought you were not being serious, and then an attorney got their eyes on it and went, oh, okay, that's it. So that's the first, like again, right? A case can settle at any point up until a verdict is delivered. And so in that position, it might resolve there soon. Maybe not, but it's possible. Then there will be more litigation, potential other fights, right? Work that myself or any PI attorney would do. Then the next step probably is going to be your deposition, right? The defense is going to want to see how legitimate you are. If you're going to be just spouting crazy talk, if you're making stuff up, right, is really what they're going to be looking at. But that's the first time you put yourself out there. Now I'll tell you, a deposition can be anxiety inducing, but it's a lot. You can take it very slow. It could be recorded. Your attorney will be right next to you though. Your attorney should be doing some kind of preparation session for you in a deposition, right? Going over how to answer questions, and it's less about like what answer to give, but how you approach it, and kind of the way to think and to slow down. And right at the end of the day, to be honest. And I think too, another thing to be thinking about here is if you're standing up for yourself and you know you're being honest about what happened, you have nothing to be ashamed of, because that's kind of like bravery, right? That's the inherent fear of a situation and standing up to someone bigger than you. That's what you're doing in this context. So there's that deposition. And then I'm thinking like a case has been filed. Your deposition might be within the first year. The potential of going to trial in New Mexico State Court is likely between 1 and 3 years. And I'd say 1 is less likely. You'll probably be in court in less than 3 years if you go to trial. Majority of cases do not go to trial because after the deposition and discovery, you are going to have a mediation conference. New Mexico requires them. And whether or not you settle, you don't have to settle at the mediation conference. And again, that's a good thing to prepare for with your attorney. But at that mediation, you're going to have a chance to kind of discuss with your attorney and a mediator really the value of your case. Now, you don't have to settle there. And again, the case can settle anytime until a jury verdict is delivered or a judge's verdict is delivered. But then from there, it proceeds to potentially preparing for trial, right? Let's say you think your case is worth $1 million and the defendants offer $25,000. You know you kind of got to go to trial to get at least part of what you're due. Whereas if you're about $5,000 difference, you want $35,000 and the defense offering $30,000, the likelihood you settle even after mediation is still high. So then that's all at the point where you're maybe going to trial. And if you go to trial, right, that can be, again, anxiety inducing. I think a lot of the time people get worried about that. They find that juries are compassionate and understanding. And just really depending on your story, it's best to have your attorney talk to you about it beforehand. You're going to do a lot of preparation for trial. But I think all of that kind of puts the cart before the horse. Because if you've gotten to that point, you're worried about calling an attorney to start a claim because you're worried about trial in 3 years. I think the thing to remember is that the likelihood of that is low, but there's a lot of steps along the way that can kind of help guide you to whether or not you're going to get there. And you hopefully have somebody who you can, like a lawyer as a counselor, somebody who can talk you through it and make you feel more comfortable as things get there if they go to that route. So I hope that no matter what you do, if you're sitting on a claim, you're like not sure what to do, call an attorney, talk to somebody and figure out what options you have and what that might look like, right? And then you also, I mean, at the end of the day, if you don't want to go to trial, you get close, and you only get a certain amount of money and you don't want to go forward, that's your choice. No attorney is going to force you to, or shouldn't force you to go to trial. And if that's a bigger concern, but no attorney is going to force you to go to trial based on your claim. That is up to you. So I would highly recommend, if you're not sure what to do, give an attorney a call. Personal injury attorney is going to not charge you anything for a consultation and figure out where to go next.